Hi, I'm Tony Suarez, former legislator, law professor, and host of I Need to Know podcast, a program dedicated and part of the Public Trust Network, dedicated to bringing you information in that crossroads between law and politics, not just in the United States, but particularly in Puerto Rico. Today, our guest is Edith Abendua, who is an expert in legal malpractice, will be talking to us about what she's going to be speaking about during our conference in September. We'll be right back. Hi, Edith. Thank you so much for joining us today and giving us a couple of insights as to what you plan to talk about at our conference in a couple of weeks, actually, at this point, as being preparing for all year for this thing. But it's such an interesting class that you're going to be teaching, because every day I have young lawyers come to my office. Many have clerked for me and they go on. Some of them have come on. I've had 4 former clerks go on to become judges, And so you begin your career someplace. And a lot of young lawyers are coming out of school, don't have exactly a place to go. And what I've seen as a recent phenomenon, all of a sudden go out and try to open up their own practice. But that is so full of pitfalls. And so we decided this year that at the conference, while we're talking about political issues and issues that are affecting Puerto Rico and the Constitution, let's get down to the brass tacks of some of these lawyers who are thinking about going into private practice and don't know where to even begin. So I asked you from last year, we thought about doing this course, and here we are talking about legal malpractice or best practices and strategies, which is what the actual name of the course, but it's how to avoid getting in trouble. All right, how to avoid getting sued right from the beginning, because that is scary. Again, when I've had represented lawyers before the bar, young lawyers who made mistakes, and then all of a sudden they have to try to straighten this thing out. And so while at the law schools they teach a lot of stuff about ethics, it doesn't really get into their brain as much as when an actual practice. So, please, Edith, talk to about, your experience and what you do for a living.
Yes, Anthony, thank you for having me here. I'm very excited to dive into this topic here today, even though it's brief. But first of all, just wanted to say hello, everybody. And I'm Edith Abendua. I'm originally from Šilutė, Lithuania, a very small country in Eastern Europe. And I'm the founder of Professional Insurance Experts, where for over a decade, I've been specializing in malpractice coverage and also professional liability for other industries as well. So we've been working mainly with lawyers, architects, engineers, IT professionals, real estate, and other industries. And so I have seen a thing or few in terms of the claims that come in, and malpractice claims in particular, and the risk areas that some attorneys might have a little bit harder time to navigate. And some of these things are a little bit hard to foresee, but they're not very difficult to prevent from happening. I always say prevention is key. That is the most important thing to do. You don't want to find yourself in the middle of a malpractice claim. A little bit about me. I have a bachelor's degree from LCC International University. I have an MBA in business management consulting from Benedictine University, and I've had quite a few advanced courses in risk management. Besides professional life, I have a passion in figure skating. I'm a former gold medalist in US 2012 figure skating adult championships. So you can say I know a few things about slippery situations and navigating those. So I think that in life, in business, as well as on ice, balance is always the key. So I am definitely very excited to go over some of the key items that I will be presenting at the conference. And obviously, we don't have a lot of time. I could talk for hours about every one of these items and every one of those key topics. But I wanted to go ahead and perhaps just touch base on a few of those and list a couple of items that I will be discussing at the conference that are quite easily preventable with a little bit of work up front from the attorneys. So I guess my question to you, Anthony, since you are an attorney yourself, besides all the other businesses that you have, I wanted to ask you what your biggest malpractice fear would be, or what do you think when you think malpractice fears?
I tell you, well, this particular podcast is an introduction to all the stuff that we're doing in at the conference, not a substitute for the going to the conference and listening. Okay, and by the way, this will be also for lawyers. This will be as a CLE credit, so that if you take this course and you complete it, you'll be able to get the CLE credits from the Florida bar. Now, I tell you, there's tons of topics here, and all of which I've reviewed your description and all the slides and everything, your presentation, totally complete, and it's wonderful. So everyone should be taking it, even those that have some years of experience, because you end up repeating. You get sloppy as you get older. You get lazy, and then these things slip through. But I thought that there are two things that I like to explore. One, you speak about billing practices and the professional conduct, which I call expectations. When you talk to a client, you have to manage the expectation of the client. Now, I've been practicing for 47 years now, and the one thing why I have been enjoying such a wonderful, I think, thank God, I enjoy a great reputation in our community, and I've never had a problem with the bar. And it doesn't mean I have problems with clients. You have problems with clients, all right, but it doesn't come to the level where they can actually make a claim. And this is where, because of communications, you have to continue to communicate, because a lot of young lawyers, Edith, just don't want. They're afraid. They hate to give the bad news, So they hold back, and then you've got the question of fees. How to charge, how to appropriately charge. Young lawyers have a tendency of taking everything that walks into their office just so they can get a fee, without knowing how much work is actually going to take, how long they put in hours, and they find out they're making $2 an hour, because at the end of it, that happens. So those are very difficult things to learn, how to charge, how to have, particularly if you've never done that. If you're not in the retail business, all of a sudden you're in college, you go to law school, now you have to tell them, how much am I worth? And you don't even know how much you're worth, right? So those billing practices and client expectations are very difficult. Of course, you're going to discuss deadlines and a whole bunch of other stuff, but I would wonder if you could explain your experience with these communications and billing.
Yes, absolutely. So you've touched on a very great and number one point. And so fee disputes is the number one malpractice trigger from what we have seen. It's just been, and this is why I'm sure most of the attorneys have a malpractice policy in place to cover them. And they will always have a question on the application: how many lawsuits for fees have you had within the last year? Now, obviously, there is a reason why the carriers ask this question. I don't think that there is an attorney that has not had a situation with unpaid fees. And if we are a client and we are getting an invoice and we have to take a double take at the invoice because we don't understand where those fees are coming from, that is where the situation really arises, where you're putting yourself in a position where the client might not want to pay. So it's very important to be very transparent on your invoice practices. And obviously, we have to discuss all of that in a very good engagement letter. What are we billing? How are we billing? What are we not billing for? It all has to be a little bit of work up front. Does humongous benefit to your practice as preventing you from those lawsuits down the line. Now, you might ask, well, if I am suing my client for unpaid fees, which happens quite often, We've seen some attorneys have 10 lawsuits in a year because they just can't get paid. Why is that a risk for my malpractice, right? I should get paid. I did my work. Well, obviously, the malpractice risk rises. Why? Because in turn, the client might countersue because of the service, or because they think that the fees were not fair, or they might not have liked the service. So your risk of potential malpractice goes quite a bit up if there's a lawsuit for fees. And so there are ways to avoid it by just being transparent in all of your billing practices. How do you charge, and explaining, keeping that open communication with the client, explaining what the fees are there for. And I'm just curious if you've ever had a lawsuit for fees, and if that went smoothly, or any situation with the client, and whether that went smoothly for you, or whether you've seen it escalate in your practice. So I'd be curious to see your input in your situation. Have you seen how this easily can escalate to something further?
Yeah, because what happens, of course, with the young, I guess this comment is addressed to young lawyers. You're going to have a lot of young lawyers there, and third-year law students, because we're making a big effort this year to bring in young lawyers, would-bes. So I've got a committee just dedicated to bring in young kids from young lawyers, okay, from FAMU, Barry, Mercer College, and Florida International.
Mhm.
But what happens is if they go out on private practice and they want to get the client, and because they've got overhead and they want to accept it, so they will charge a fee that may be low, just to be attractive as compared to a more expensive attorney or more experienced attorney. But then what happens is that they realize that they're working for free, or they have a very demanding client, because you don't know how to weed out that demanding client. That's a skill that takes time for you to see, oh, this client is going to be a difficult client to satisfy. Nothing I do will ever satisfy this client. Those type of persons you really have to try to avoid. And that, as an attorney with 47 years experience, I spot those the minute they walk into my door.
Really? Yeah.
So this client, I don't care how much money they want. I'm not going to take this case, because of the type of client. That's difficult to do and difficult to learn as you're first starting out a practice. But as you're starting, being very clear, you have to tell the client, listen, this is how much I'm going to charge you, and this is how I'm going to bill you. I'm going to bill you by the hour, or it's a flat rate. And if it's a flat rate, what to expect. This will take you to 2 motions. This will take you to 3 motions. This will take you up to the trial. Very, very careful to avoid a misunderstanding, because lack of communications leads to the complaint, and leads to dissatisfaction in your practice. A lot of young lawyers leave the practice because they just get overwhelmed. It's overwhelming, the amount of work that they have to do, and they're not satisfied with the work that they're doing. And I was wondering if you guys kept the statistics on lawyers who left practice, how long that happens.
I have not seen that. I have seen a little bit of a slowdown, perhaps during COVID. But besides that, I have not seen a lot of attorneys leaving the practice in my experience. They have been quite resilient, and they might move states and try a different area of practice. But the attorneys they are very resilient, and they're very persistent usually. But I do know that they go through a lot of struggles and a lot of things that has to be on their mind, and all of these ducks have to be in a row. We are talking about ethics. We're talking about keeping up with the regulations. We're talking about cybersecurity, cyber threats, fee practices, ethical dilemmas, conflicts of interest. All of these have to be on the forefront as an attorney, because all of that exposes your potential malpractice claim. And you've touched a great point where you said, be transparent upfront what you can do for the client. And that goes further than just the fees. That goes it is very important to disclose what you will do in your engagement letter, what is the service that you're providing? And actually, a very recent malpractice case that has been quite public, and I've actually posted it on my LinkedIn page for people to read. But that was the case on the engagement letter where the attorney specifically indicated what they will do and what they will not do. So they specifically said that we will, represent you in the workers' compensation case, but we are not going to represent you in any other case or any other insurance claim that might come in. And that saved them. The judge sided with the attorney because of that, because eventually there were some additional claims that came in from other areas, and the client sued the attorney for them not letting them know what to do with that additional situation. And the judge sided with the attorney just because in the engagement letter, they said they would not represent them in any other case not related to workers' compensation. So being very clear, concise up front, especially for young attorneys, it is something that takes a little bit more time up front, but prevention is key here. It's better to prevent upfront than face yourself in the middle of the claim later.
The Florida Bar keeps statistics on the number of lawyers that have, we have high divorce rates, and we also have, high alcoholic rates, and the bar has programs for lawyers to deal with these problems. Because like everybody else in the community, we'll have people, they're just human beings, and the stress of the job often will cause people to go into bad habits or suffer, indiscriminately, so also for us to be understand. Now, your course is going to discuss even more stuff. It's going to be about fee disputes. It's going to talk about deadlines, ethical questions, CLE requirements, cybersecurity, which links into another course we're doing on cybersecurity as well. But it is a very robust class that you will be offering. And I really suggest that all those are paying attention. Everyone shows up at the attendee, really attend that class because unfortunately it's the first class. I think it's the first class on Friday morning, it's going to be a great course, and I think it's going to help you a lot. And also, young lawyers, you're going to meet other lawyers, and you're networking with them and meet them. And you remember, Edith, I remember you at the dinner last year. What a great opportunity it was for everyone to meet with each other, discuss and become friends. This way you exchange business cards, and those people from Chicago or from New York, or who knows what relationships can be established at this conference. So for those of you who are saying, what's this conference? Because it's the first time you plug in, know that September 26th through 28th, we'll be having a conference what we call the Puerto Rican Bar Association's National Conference. It is a work of 3 bar associates from Chicago, from Illinois, Puerto Rico itself. By the way, I'm on my way to Puerto Rico this weekend to address the Colegio de Abogados in Puerto Rico to their assembly to entice them to come, as many to Puerto Rico, to our conference in the next 2 weeks. So I'm excited about that opportunity as well. But this conference about the bar in New York, Florida, Illinois, is an attempt to try to get a consensus to deal with the question of the constitutional question of the status of Puerto Rico. We have, I'm just a shorty, but Puerto Rico has a birth rate of 1.26 children per woman. The replacement rate is 2.1. That means that Puerto Rico is dying. It is in demographic winter. There are reasons for that, economic and social. But part of that has to do with Puerto Rico, of course, does not control its future. It's not sovereign. It is neither a state nor is an independent country, and therefore cannot control its future. And that is a condition because it's in a territorial status. So we will have experts from around this country actually talking and giving courses about how this is, why this is, the recent case law on this, and what can be done about this as a people. And I urge those who are listening that this is not for Puerto Ricans, because Puerto Ricans don't vote, or they cannot vote. They have no vote, so they can't help themselves. We have to help them. Those of us that live in the main side. That's why people in Montana and Utah and California, they have more power over the future of Puerto Rico than Puerto Ricans. So without a national platform, which is what we're trying to create, a national platform to have this discussion, ultimately, maybe not in my lifetime, but shortly we will hopefully have a convention large enough that national presidential candidates have to show up as they do for the National Rifle Association or for the Christian Coalition or for the National Association of Black Journalists, right? These conferences call upon the presidential candidates to show up. When we can do that, when we have reached this conference at that level, we would have perhaps start moving the needle on the issue of where Puerto Rican goes from there. So Edith, thank you so much for joining us this year and being a sponsor. I look forward to your class. I know everybody else will, and I see you. Thank you so much.
Thank you so much, Anthony. Thank you for having me.
Hi, if you like this content, please like and subscribe below. You don't have to be a lawyer. Just like to know what they know and how they know it. This is your place. Puerto Ricans are citizens of the United States but cannot vote for president or Congress, and only with your help will this colonial status ever end, one way or another.